For the trial of Ahmaud Arbery, developments there. Let's listen in.
Today, you are Glenn County. So why we're here is to go ahead and present you with the state's closing argument. Now, the state gets to go first and last because the state has the burden of proof to prove this to you beyond a reasonable doubt. But not just to prove to you beyond a reasonable doubt the charges in the indictment, but remember from voir dire, you were asked, can you give meaningful consideration to the defenses presented by the defense if they put any up? Okay, and what we've heard is what? Self-defense and citizen's arrest, which the state has to disprove beyond a reasonable doubt to you as well. So, ladies and gentlemen, what the state's going to do right now is we're going to go through I'm going to give you a snapshot, that kind of like, here it is in a nutshell sort of thing. And then I'm going to take you kind of through systematically, piece by piece, what the law is as it regards to charges in the indictment, self-defense, and citizen's arrest. All right? But the one thing I want to tell you before we got started is this. You will have a copy of the indictment with you in the back. Okay? So you don't have to write down the charges in the indictment. You have a copy in the back. In addition, Judge Walmsley is going to give you a copy of the law. Okay, so you'll have a copy. So when I'm putting the law up here, you don't have to furiously write it down. You will have a copy of it back there with you. All right? So let's go ahead and get started. This case is really about assumptions and driveway decisions. Now, you heard the defense talk about, well, probable cause. You're going to have to distinguish between assumptions based on gossip and rumor and all this neighborhood talk on Facebook, and actual probable cause to believe a crime had been committed and someone had committed that crime. The state's position is all three of these defendants made assumptions about what was going on that day, and they made their decision to attack Ahmaud Arbery in their driveways because he was a black man running down the street. So here's what we've got. The bottom line. They assumed he must have committed some crime that day because he's running real fast down the street, right? They did not call 911. They wanted to stop him and question him before they called 911. How do we know? Because that's what they told the police that night. That's what they said on the scene. Hey, stop, we want to talk to you. Can't do that. They made these decisions in their driveways. So what's really going on here? You know what's really going on here. Mr. Arbery was under attack. They committed 4 felonies against him. And those are the 4 felonies in the indictment. Then they shot and killed him, not because he was a threat to them, but because he wouldn't stop and talk to them. And they were going to make him, absolutely make him stop. We're going to point a shotgun at you. That'll make you stop. That should make you stop right here in your tracks because we want to talk to you. And what did he do? He still ran away. Still ran away. For 5 minutes, ran away. Travis McMichael went to intercept him with that shotgun, and he turned that corner. We can't see whether Mr. Arbery attacked him or grabbed the shotgun or anything. It doesn't matter. Because how fast did he shoot him? How fast did he just pull that trigger? They shot and killed Ahmaud Arbery. They all acted as a party to the crime. You'll note they've been indicted that way. And I'm going to talk about what party to a crime is so that you understand that concept. But the bottom line is, but for their actions, but for their decisions, but for their choices, Ahmaud Arbery would be alive. And that's why they've been indicted with murder, felony murder, and the 4 felonies that led to the murder. So what is the defense? I mean, I'm just going to take it right down there. We talked about that. What is the defense? We got self-defense. What is that? Well, they're going to try and convince you that Ahmaud Arbery was the attacker, that he was somehow threatening to them. 3-on-1, 2 pickup trucks, 2 guns. Mr. Arbery, nothing in his pockets. Not a cell phone, not a gun, not even an ID. They want you to believe that he is the danger to them, and Mr. Rubin said it in the opening statement. He was scary. So, here's the thing. They're going to try to claim that they were justified in their actions. Okay? Because here's the thing, ladies and gentlemen. You cannot claim self-defense under certain circumstances. You can't. You don't get to say I was acting in self-defense, and there's 3 of them. And it's the law. This isn't just something made up. There's 3 of them in the law. Okay? If you are the initial unjustified aggressor, you don't get to claim self-defense. If you're committing a felony against somebody, you don't get to claim self-defense. And the 3rd one is if you provoke somebody so that they defend themselves against you, and then you go, oh, look, he attacked me first. But you really were the one who was provoking the attack on yourself. You don't get to claim self-defense. And that's the law. So, here's the problem. They're going to try and claim they were justified in starting this in their driveways. They're going to try and claim they were justified in committing all these felonies against Mr. Arbery. How? Because they're going to try and convince you that this was a citizen's arrest. That's what they're going to do. But here is what a citizen's arrest really is. Okay? This is what the law says. This is the statute, and the judge is going to give it to you. A private person may arrest an offender if the offense is committed in his presence. Right here, right now, I'm seeing you do it. Okay? Right here, right now, I'm watching you commit the crime. I'm witnessing it. You're doing it in my presence. So what's the problem for the defendants? Well, we all know that Mr. Bryan's on his porch fixing it. Where's Travis McMichael? He's on the sofa inside the house. Where's Greg McMichael? This all started when I saw him running down the street. Now, it also says, or within his immediate knowledge. Well, the judge is going to charge you that that's synonymous. It means the same thing. So you got to think about, well, in my immediate knowledge, what does that mean? Think about the eye in the sky, you know, at Walmart. Like you're in Walmart, right? And you see all those things in the ceiling. You know there's a guy in a booth watching a bunch of video cameras, right? So he's not standing next to the person shoplifting, right? When she shoplifts, right? What's he doing? He's watching it on the camera. That's immediate knowledge. He's not right there next to the person shoplifting, but he's watching it. So he has immediate knowledge because he can see it eye in the sky. That's just an example. How to think of immediate knowledge. But immediate knowledge and in your presence is the exact same thing. In order to make an arrest of an offender, the offense has to be committed in the private citizen's presence. Do we have that here? No. In addition, you will be charged, this is the 2nd line, if the offense is a felony. So once again, the offense has to be a felony. The judge is going to charge you. Criminal trespass and loitering and prowling are misdemeanors. Okay? I'm going to pause right now. I'm going to ask you to read the criminal trespass thing. In order to be a criminal trespasser, you have to enter on the property with the intent to do an unlawful act. Or somebody has to have told you can't come back here. Like Larry English or his representative. Well, Mr. Arbery was never told, don't come back here. You're not allowed. This is private property. He was never told, so he doesn't fall under criminal trespass.